Using evidence discovered through the investigation and the input received from the team, the prosecutor's office determines if there's enough evidence to press criminal charges. If criminal charges are filed, the person accused of abusing the child may be arrested, or they may receive a summons, and they must go to court for an arraignment. An arraignment is when the person accused of abusing the child, called the defendant, appears before the judge and pleads guilty or not guilty to the charges. If the defendant pleads guilty, sentencing will be scheduled for a later date. Defendants almost never plead guilty at arraignment. If the defendant pleads not guilty, the case will continue through the court process. Also, at this stage, a bond is set by a judge. If the defendant cannot post bond, he or she will remain in custody while the case is pending. There are two types of hearings that may occur before a trial: a preliminary hearing or a grand jury hearing. A preliminary hearing will take place before a judge in an open court, and the judge will review the evidence and testimony and decide if there is enough evidence for the case to proceed to a trial. A grand jury hearing is held in private before a jury. The defendant and defense attorney do not attend. The grand jury reviews the evidence and decides if there is enough evidence to hold the defendant over for a possible trial. The defendant will have an attorney called the defense attorney. This lawyer may want to talk with you or your child before the trial date. Although you may choose to talk with this person, you and your child do not have to talk to the defendant's attorney. If there is a trial, the defense chooses if they want a bench trial or a jury trial. A bench trial is held before a judge, and a jury trial is held before a judge and 12 jurors. During the trial, you and your child might have to testify. The defendant does not have to testify. It may take several months from the time charges are filed until you go to court for trial. Once all evidence and testimony are presented, there will be a verdict of guilty or not guilty. If found guilty, the defendant will be released if he or she has no other pending charges. If found guilty, the defendant will be sentenced at a later date. Prior to the sentence hearing, you will be contacted by a representative of the Commonwealth Attorney's Office, and you will be asked to complete a victim impact statement. The judge will read the victim impact statement before he or she decides what sentence to impose upon the defendant. You and your child will also have the opportunity, if you choose, to read your victim impact statement to the court at the sentence hearing. The Commonwealth Attorney's Office will help you prepare your victim impact statement. The case can also be settled by agreement without a trial. This is called a plea bargain. A plea bargain may take place between the prosecuting attorney and the defense attorney at any time and is reached when the attorneys agree on a charge and sentence. If the judge accepts the plea bargain, there will not be a trial. Although a plea bargain ensures the defendant will be convicted, oftentimes it results in a lesser sentence. As a result of a plea bargain, a conviction will appear on the offender's records, and he or she may have to register as a sex offender. Many times, a defendant will plead guilty, but there is no agreement between the attorneys about sentencing. In that event, the case may be continued for a sentence hearing. At this time, the judge will decide the sentencing. If this happens, you will be asked to complete a victim impact statement.